This case has been sort of inching along. There's been some half days along the way. Today, we're expecting a full day of testimony. Let's bring in John Day. He's in Santa Fe, New Mexico. The defense is pretty spirited. The attorneys representing Mr. Palmer have been, in my opinion, on it. I mean, they have just been pushing and pushing. They've asked for a mistrial, I believe, on 2 separate occasions, brought in jurors in this last incident. What's your overall take from this trial, from what you've seen? I know you haven't seen all of it, but you've got this guy who is claiming self-defense. The video is really not helping. It's not. It's more questions than answers kind of scenario. Does he take the stand, and how do you think it's going overall so far for each side?
Ted, well, thanks for having me. So what the defense has to do is try to convince these jurors that this was a reasonable action by the defendant. And, he was attacked. He says he was he feared for his life. So what the defense has to do is attack the key piece of evidence, which could be this video, the surveillance video, the ring video, the doorbell video. What we say is the video doesn't lie in a trial, but the defense is trying to bolster the idea that the video that was collected by the police was insufficient. The video does not back up the idea that this was not self-defense. And so the defense experts on the stand saying, this video, it's unclear from it. It was, the collection was done poorly. There's some issues with how it was gathered. You can't really see what really happened from the video. So the defense is trying to establish the idea that the video does lie. And so they're being very aggressive about that, because that's one of the pieces of evidence that the prosecution hopes is going to convince the jury that this was not self-defense.
Yeah, and for the defense, it's key, because you have to make sure jurors focus on what they can't see because of the quality of the video, and that can be dicey. There's another thing that happened on Friday which could really help the defense, and that is the sergeant got on the stand, and this question about whether or not the victim was armed or not with a knife came up, and this is how it played out.
And you thought, in this case, that Stephen Campbell was unarmed, didn't you?
I did.
But it turns out that he wasn't. Is that correct?
All the information that I had from talking to Detective Cervantes, who was on scene, indicated that he did not have a weapon in his hand at the time of the shooting.
But you now know that he did have a knife in his pocket, right?
I know that he did have a knife in his pocket, correct.
And Mr. Martin, when did you learn about the knife?
I learned about the knife probably within the last week.
Within the last week? And it's been, I think, over 495 days since this arrest, right?
It has.
It's been over a year, right?
It has.
And nobody told you about the knife until now?
Correct.
You didn't go through the evidence and see the knife until now?
I didn't go through the evidence and see the knife? No.
And Detective Martin, part of the reason you came to your conclusion about self-defense was that you believe Stephen Campbell to be unarmed, correct?
It was one factor.
And Detective Martin, is it true that that you stated, as to necessity, the investigation showed that Campbell was unarmed during the incident and thus unlikely to inflict imminent death or serious bodily harm, right?
Correct.
Can a knife be used to inflict imminent death or serious bodily harm?
It can.
So how important is that, John Day, the fact that the investigative detective says, I just found out about the knife in the pocket, it was in the pocket, last week?
A couple of things. First of all, the defense is trying to point out this was a sloppy investigation. It's trying to build the case that the police didn't do their job But the second point is there may be a knife in the pocket, but the defense has to establish that the defendant was somehow aware of that, and that was something that was a factor in what happened during the killing. So the defense has found this little nugget, which of course makes the investigation look sloppy. But they also have to be able to use that. They have to be able to use that evidence to leverage the jury into believing that because the victim had a knife in his pocket, that there was a justifiable reaction by the defendant. And so this is what they're going to have to play out. They're going to have to establish in the minds of the jury that the knife was there, the defendant perceived it, and that this will support a justifiable reaction, a justifiable self-defense killing.
Yeah, and again, you think that's going to add pressure on the defendant to take the stand and tell his story about seeing the knife in the pocket somehow. We'll see, whether that is part of the equation here or not. But interesting the way that played out. It just, you could tell the sergeant was definitely on the defensive, and jurors sometimes react to that maybe more than they should. Let's get a break. When we come back, we'll get into the courtroom for testimony. It's a new week in the case against Mr. Palmer in the great state of Montana. We're going to watch it play out when we return. All right, if you're just joining us and wondering where's the testimony, the jury is not in the courtroom. The defense is raising another discovery issue. It's the fifth one since this trial began last week. This is only day 4. John Day still with us. What's your take on this, and if there's any legitimate traction here for the defense for a mistrial?
Well, Ted, the defense is doing what they have to do. They're trying to paint a picture for this judge of incompetent prosecutorial activity, incompetent police investigation. The bottom line is this so-called newly discovered evidence. How important is it? Is it something that would be monumental for the defense in establishing its self-defense claim? The judge is going to have to weigh what the evidence is, why it wasn't produced, and really, does it have any effect on the defense's strategy? Does it have an effect on how the defense prepared their case? These things do happen in the middle of trial. It just depends on what for example, newly discovered photographs coming from a police officer's body-worn camera. Is it something that's new? Is it something that's significant? These are tough calls for the judge. Ultimately, it's pretty rare, unless it's a real significant discovery violation. It's pretty rare for a judge in the middle of a murder trial to toss the case. But the defense is doing what they have to do. They're trying to say this is one of many discovery violations, Judge. It's cumulative. It's the effect on the violating the defendant's right to due process, the right to a fair trial. It's a tough case for them to make, but it's what they have to do.
Yeah, absolutely. And they're setting, building the record. And it seems pretty significant at this point in terms of the sheer number of discovery violations that have come up. And you got this knife that one of the detectives didn't even know that the victim had on him, and then that knife was destroyed, so the jury never gets to see it. Do you have to be careful what you wish for? This guy is not out on bail, and if this were to be dismissed, it would likely not be with prejudice. He'd be looking at another trial, and if you think you've got momentum in a trial, you're monitoring the jury, you're seeing, back and forths. Maybe the last thing you want at this stage is for this to stop and restart 6 to 9 months from now.
Right. Again, that's always a risk, but the defense at this point, if they have a chance to gain an advantage here, if this judge is actually going to go ahead and, toss the case because of these discovery violations, at least that's something of a win for the defense. But it's all going to depend on what this is. Is the judge looking at this and saying, this is very similar to evidence that we've already had, that was already turned over to the defense, or it's something so significant that its absence had a real effect on how the defense prepared their case, how they got ready for this, and other investigation that it could have led to. So it's really going to come down to very fact-specific analysis of what this missing discovery was and how it put in the puzzle pieces for a self-defense claim.
Yeah, great point. And the state's saying, hey, listen, we're not going to use it, and it is a version of the body camera that they've had for the entire time. Let's get a break, see what the judge decides when we return, and then we're expecting testimony to resume. Day 4 of Montana versus Jordan Palmer.